I'm delighted to welcome you to this evening's launch of Gautam Bhatia's new book, Unsealed Covers, A Decade of the Constitution, the Courts, and the State. We have a very distinguished panel with us today to launch this book, and I would like to warmly welcome our panelists, Justice S. Muralidhar, former Chief Justice of the Orissa High Court, Senior Advocate Rebecca John, and Seema Chishti, editor of The Wire. Before we move on to the launch and discussion, I will briefly introduce the author and the book. Gautam, as a lot of us know, is a lawyer who's been involved in several important constitutional cases in the recent past. HarperCollins India published his book, The Transformative Constitution, a Radical Biography in 9 Acts in 2019. He also writes science fiction, and The Wall and The Horizon were published in 2020 and 2021, respectively. Unsealed Covers marks, in a way, Gautam's return to nonfiction. In this book, he casts a questioning and critical eye at the past decade, which has also been the decade when the NDA has been in power at the center for 2 consecutive terms. It is commonly accepted that the NDA years have generated a significant amount of conflict within and around democratic institutions meant to act as checks and balances against majoritarian power. One of the most important theaters of conflict have been the judiciary, and in particular, the Supreme Court. In this book, in Unsealed Covers, the actions of the judiciary and its relationship with the government have been closely examined, and some of the most important judgments of the past decade have been critiqued as well. Before we begin what promises to be a very interesting discussion, I request everybody who's on stage to formally release the book. Basically, you get up and you hold it up for a photo op. Thank you, and I now hand over to Seema, who will be our moderator for the evening, to take over and begin the discussion. Thank you.
Thank you so much. Can I be heard? Yeah, this is being. I can, yeah? No? Okay, yeah, sorry, I was noticing the light green. A very good evening, and thank you, Swati, and it's a pleasure to be here, a privilege and a bit of a scary proposition. Gautam's blogs always would kind of worry us because they would sort of bring so much home so quickly, force you to think, force you to know, to find out, to care. So it's really nice kind of to see it all in a book. I thought we'll do it like this, get our distinguished panelists, my co-panelists, to speak quickly about the book, and then we go into kind of more substantive issues, and then throw the floor open to this very distinguished audience, and you can pop your questions to Gautam and whoever you wish to. So Rebecca John, feisty, senior advocate, and you know, with all the sort of start.
Okay, in order of seniority, it should have been Murli, but anyway. So this is a fascinating book. I told Gautam that I tend to read his blog before I read a judgment, because it makes my life easier. I get to know what Gautam is thinking. This book is actually in 3 parts. It's very interesting. The first part is on rights, the second part is on constitutional structure, and the third part, which you must all read, is on the judiciary. I won't talk too much about the rights at the moment, because I will be later on dwelling on UAPA and what Gautam has written about the application of UAPA. But what I found quite fascinating in this book was the way Gautam critiques several judgments. For example, in the Puttaswamy judgment, Gautam has argued that the judgment of Justice Chandrachud and Justice Indu Malhotra opens the doors for interpreting Article 14 and 15(1) of the Constitution. And he wonders whether Justice Chandrachud's observations on limits of criminal law have an impact on litigation concerning bans affecting dietary preferences. whether salutary observations about transformative constitutionalism and the value of the individual would percolate into other cases concerning state power and individual rights. Now, as you know, the journey from 2017, when Puttaswamy was delivered, and 2023, a time when state power has entirely eclipsed individual rights, some of Gautam's early questions have been answered in the negative. Because subsequent judgments of the court, including long delays in pronouncing judgments, have not really upheld the idea of transformative constitutionalism. So while critiquing the Supreme Court's judgment in the hijab case, a judgment pronounced in October 2022, Gautam writes, and I quote, "I have noted on the time that a close reading of the judgment reveals how uniform haunts the court's imagination on every page. Lurking behind the High Court's judgment was the unarticulated belief that allowing the hijab would open a floodgate that would end in the destruction of the very idea of a uniform without which education was unimaginable." He goes on to critique Justice Hemant Gupta's response to virtually every argument made in court. The uniform, Article 25, and the freedom of conscience. The uniform, Article 19, the uniform, Article 21, and the right to privacy. Most verily, the uniform, all moral and constitutional values have come to repose in the uniform. Now, recall Gautam's 2017 observations about Puttaswamy, whether the salutary observations of Justice Chandrachud about transformative constitutionalism and the value of individual rights percolating into other cases concerning state power and individual rights. In less than 5 years, his question was answered when regulation, uniformity, homogeneity was used to justify the restriction of the freedom of conscience under Article 25 and 21. He goes on to dig deeper, and you will find what really animated Justice Hemant Gupta was the idea of discipline. And the word discipline, according to Gautam, occurred 22 times in the judgment, with Justice Gupta emphasizing that discipline would not exist without uniform. In contrast, Justice Dhulia's judgment talks of a space where the governing principle is not discipline, but freedom, where the idea of fraternity requires us to embrace and express our differences rather than flatten and erase them. As I said, I found the last chapter of the book very fascinating, where Gautam profiles 5 Chief Justices. Chief Justices Deepak Mishra, Ranjan Gogoi, S.A. Bobde, M.V. Ramana, and U.U. Lalit. He's been critical of all of them. And he himself clarifies these profiles seeks to critically analyze not just the legacies of these Chief Justices, but the nature, character, and the direction of the Supreme Court as an institution under them. He also argues that the master of the roster position, which gives the Chief Justice enormous administrative powers, actually decides the fate of cases. I've thoroughly enjoyed the book. I think I've exceeded my 5-minute limit. Over to you.
No. Oh, God, now when a judge says that, you listen. All right. So I mean, I'm coming to it from another lens. I'm a pakka outsider to this, deeply concerned, sometimes hopeful, sometimes awestruck at watching these proceedings. So as an outsider, I'd like to first talk about the blog. So I know the book is out and the book merits all our attention, but I think understanding the blog that Gautam does is very important. The fact that he does this at a time when blogs are completely going out of fashion. As a communication device 10 years ago, blogs were on the wane. People were jumping onto, Medium was meant to be this big hot thing, but it was not the hot thing here. People were just departing from blogs. And I think Gautam stayed on the blog because it gave him the right kind of medium, the right way of communicating on his terms, that he could be crisp, he could be immediate, and he could be deep. He could be as deep as he wanted to and get away. So I think it's actually quite unique. I don't see any other person in any other field really picking on the blog 10 years ago at a time of so much tumult in terms of information and how communication happens, and to stay with it. So the blog was great. The blog also, I think, because it's chronological, it was almost like a Google Street View suddenly, in terms of anybody wanting to see the slide, the upclimb, or the gradient of how the judiciary has gone, or how the great institution of judiciary is kind of behaving across time. It was an excellent index without even wanting to do that. So the book, I think, is like really good too, because, you know, as good as, I was actually very disappointed when the book came first, when I saw the cover and I said, oh my God, Gautam has turned his blogs into a book, till I started reading them. And that's when I saw what he's done is to thematically kind of arrange it, to update things. It was almost as if light bulbs are coming out, you know, suddenly being lit up, and it just lit up another pathway. It was just another way of looking at what had happened, not purely in terms of time or being burdened by the whole rush that like all of us are in, and particularly somebody like me in my trade, we're constantly, you know, the clock is always being wound up. So it actually gave you repose, it provides a compass, and it provided me with a map again of how things were. So those are two very good things. I think about Gautam's book and the writing, what it always does is he's sticking to the first principles. I think he's sticking to the pristine first principle in even the most kind of horribly written judgment which exceeds 1,000 pages, is his great ability to juice that out. He's sticking to the first principles. He's never missing either the woods or the trees. That, I think, is like a delightful thing. He's never like heading off into some irrelevant part of the judgment or just overemphasizing on another part is very good. There is also one thing he achieves very well, which is really a triangulation between the law, the constitution, and politics. He's able to somehow just get the triangle sorted and put it out in his blog. It's a very interesting also, the second point I want to make about the book, to watch Gautam's evolution in his thinking. So forgive me if I'm wrong, Gautam, but you know, there is a bit of a definite way in which there's a definite Gautam Bhatia in the beginnings. And slowly he's kind of diving deeper into the complexity. And by the time we come to the tribute to the previous Chief Justice of India, he's leaving you with such a thorny question in the end, that how do you weigh somebody who frees two important people who were put behind bars for no reasonable reason, but how do you weigh that against a sexual harassment bench case that they sat on? And in the end, Gautam almost ends, with something that he took from speculative fiction, that he ends with this idea that he doesn't quite know. How do you weigh the spirit, the freeing of the human spirit versus other actions of that Chief Justice? So that maturing is also brilliant. And I think the third thing that, and a very important thing that this book does, and certainly did for me, was actually kind of litter the conversation and the dialogue about the judiciary and the thinking and talking about it with phrases and meaningful propositions and concepts that he gave us, whether it was, the judicial evasion, whether it is the doctrine of this, that, and the other, whether it was the doctrine of the sealed cover. So to be able to kind of put all that, so I'm sure that's common parlance with people, in courts, etc. But for people like us who are kind of slightly outside, it really provided tools to enrich the conversation. So I think while Hindi cinema and serials have gone a big way in making this courtroom this very happening place, very wrongly a lot of times, but they've at least put some interest there. He kind of really added muscle and depth. So I think that was like the good thing. So the book really spoke to me, and I hope you enjoy reading it. Justice Muralidhar.
Yeah. Thank you, Seema. First of all, congratulations, Gautam, putting all your writings together in one place. It covers a span of, I think, 10 years, 2013 to 2023. One can't help admiring this young man. He's definitely a young man from my perspective. He's 35. He already has brought out, this is his third book of non-fiction. I remember Shock, Offend and Disturb. By the way, Gautam, with your other works, you seem to have missed out Shock, Offend and Disturb here.
Oh, it's not by Harper, so it's not.
I've read most of Gautam's works, including his two fictional works. The energy the man has is just stupendous. I've heard his peers tell me, by the way, I mean, I've known Gautam since his law researcher days and law clerking days in the Delhi High Court. I've heard his peers tell me how, in a journey on an auto rickshaw from one place to the other, Gautam is writing his blog. So he's always first out, like Becky was saying, first out with his comments on a judgment. I would say the best way to describe Gautam is he's a modern day legal chronicler and who uses technology to the fullest. The earliest evidence of that was the Puttaswamy privacy hearings. When I remember, even as a judge, we were very fascinated to read the real-time tweets. I think Gautam and the other was Prasanna, who both of them were tweeting, and suddenly you got literally a commentary from within the court. So for legal correspondents sitting here, I think that was a new way of looking at how court functions. So through the book, you will find Gautam gives an insider's perspective. Even in the preface, he tells you why it is important to give this ringside view. He started off with his blog writing generally about the Constitution. And then after his law clerking days in the Delhi High Court, he said, why not give the readers a ringside view? So for instance, the NRC hearings, you will actually have him tell you the dialogue that happened in the court. Much of the dialogue actually doesn't translate into an order of the court. So very often what happens in the court is not, reflected in an order. And therefore, I think this is a very, very important book, because people who are not used to going on the net, reading a blog, and are used to reading print will find this very useful in terms of chronology of events, in terms of how an institution shaped and reshaped itself with the changing times. I find Gautam has a refreshing candor. I find that missing in the print media. I'm a product of the print media. I must confess to all of you, yesterday was the completion of 40 years at the bar for me. And I've seen the whole scenario, even the pre-electronic media and, through all of those years. I think Becky will agree with me on that. Legal correspondents who covered courts were generally had to be very restrained. First of all, you had to be careful in the language you used, in what you said about what happened in the court. Because in the Supreme Court, and you cover the Supreme Court quite a lot here, of course he also covers some of the high courts, there is a system of accreditation of journalists. I think Dinesh is sitting here, and you should be knowing, press correspondents are accredited. So which means that you can lose your accreditation if the court finds that you're not reporting correctly what transpired in the court. Then there is this editorial policy of newspapers. Now Gautam is free of that. He's his own editor. So he has the freedom which a press correspondent, which a legal correspondent, even if electronic media may not have. So I think he makes full use of it, and one has to admire the courage with which he's written this book. And as I think Seema or Becky both mentioned, he gets away with it, thankfully for all of us, because I think that's the candor we need, that insider's view of what happens. I remember legal correspondents telling me, lamenting at least, how many stories got killed. I know in this audience there are legal correspondents, they'll understand what I'm saying. They got killed at the editorial desk. It'll be interesting, after reading Gautam's book, it'll be interesting if somebody brings out a volume of killed stories. That will tell us how much was kept back, despite the journalists knowing how much of it was kept back from all of us. And Gautam is therefore, his writing is refreshing for all of us, at least court watchers like I. The other thing is the clarity with which he speaks. I just want to read this one bit where he's straight away disclaiming that he's either being neutral or impartial. He says, as many of these essays have been written from the perspective of a participant, I should also make clear that neither I nor this book is or attempts to be neutral in this ongoing constitutional struggle. I approach constitutions, constitutionalism, and courts from a perspective that is skeptical of structures of power and authority, opposed to the concentration and homogenization of power, suspicious of any form of constitutional interpretation that seeks to subordinate real, flesh and blood human beings to abstractions such as national security or larger public interest. On the other hand, and I think this is so true of who Gautam is and what his writing is all about. On the other hand, this approach supports the democratization and distribution of power, celebrates the existence of diverse and plural ways of living, privileges human dignity and freedom over invocations of rais and dawn. Further, I believe that this anti-hierarchy approach is characteristic of Indian constitutionalism in its best moments, moments that infuse life into that old adage about newspapers, to afflict the comfortable and comfort the afflicted. It is this perspective that informs the essays in this book, and it's achieved in a very, very wonderful way in this book. I remember, again, going back to legal correspondence, when you read some of the newspaper items, some of them have got scoops. Some of them have been called and, selectively information is leaked to some newspaper which says, I am the exclusive, front page scoop. So, that kind of distorts the way journalists are supposed to function. One person gets access, the other doesn't get access. And the bias then comes into the writing. You'll find journalists fiercely defending the court with their pieces. And then you begin wondering, how objective is this news channel or a newspaper? Now, Gautam gives you that refreshingly different perspective of what's happening in the court. We don't have a critical legal studies movement very seriously followed in this country, which is going into the background of judges. Where do judges come from? And Gautam's writing tells you that they do come from definitive positions. And this book actually tells you that there are many issues coming before the court where a political issue is actually dressed up as a legal issue. Becky mentioned hijab. Today we had two news items. One about the choice of food in schools in Lakshadweep, and the other about flying a flag in a temple in Kerala. Now judges do make political choices. They may think that they're being neutral, they may think that they're not having a position, but when you either accept an argument or reject an argument, you're making a political choice. And that comes through very clearly in this book, that politics and judicial functioning are not as separate as we might want it to be. It's all mixed up, and it's increasingly getting mixed up because all the issues of, what we wear, what we eat, what we speak, they're all becoming legal constitutional issues now. And they're coming before the courts. And judges are having to put their lot with one argument or the other. The judges are forced to make a choice and then make that choice in public so that you know where this judge stands. So that comes through very clearly in your book. I think Gautam does get away with a lot. So many legal correspondents sitting in the audience and who are going to read this book are going to be very, very envious of what Gautam does in this book, which he did in his blog, which is just like in page 355. I love the sentence. He says, the past is a foreign country. Then, this I must read out. He says this of one of the Chief Justices. No spoilers here, so I'm not going to reflect the name. This is page 411. He says this was a court and a Chief Justice that had liberated itself from that annoying little thing called the Constitution. Out Kaiser, out nihil. I also found it interesting that Gautam ends the book on a note that should make us all reflect why it's necessary to have these kind of books brought out, because they need to say the truth about the law. And telling the truth about the law, according to Gautam, may require a slightly different framework of analysis, a frame that is more critical, that centers the Supreme Court less, and that focuses more on the Constitution as a site of democracy and power relations, as opposed to something the Supreme Court purports to interpret from time to time. It is, of course, an evolving idea. What it will look like is something we will find out as we go along. But I believe that is a task that must be begun urgently. Congratulations, Gautam, on a wonderful contribution to all of us.
Thank you. I think I'm also surprised a bit myself that I've gotten away with it so far. No tangible consequences yet. Who knows how long that'll last. Just to begin by saying thank you to everyone who's come, specifically on a Thursday evening, especially those of you, I know there are those of you who have matters tomorrow morning, in your seniors' chambers. So thank you for coming. I want to say two things in this first round of comments. One is my positionality in writing this book, and the second is the tone, which both of which you highlighted a little bit. Positionality, so normally there is a fairly clean-cut separation between the bar and the academia, in the sense that much like judges cannot respond and are meant to speak through their judgments, once you've become a practicing lawyer whose main task is in the court, you're also meant to speak through your briefs, your written submissions, and your arguments. And specifically, in cases you've been in, you're not meant to, after the case, speak about that. unless you're CROI, in which case normal rules don't apply. But for the rest of us, we're not meant to relitigate the case outside the courtroom. I think that there are a few unique things about Indian litigation and the court that complicate this position a bit. And one is, as you said, unlike to a degree that is much greater than other legal systems, a lot of significant stuff happens in court that is not reflected in the final judgment. And this is not just the oral observations and the oral exchanges, because nowadays actually with live streaming, with LiveLaw that's here and bar and bench, you do get a fairly comprehensive picture into what is happening in the courtroom. But even beyond that, a lot of stuff happens through a one-line interim order, which will create a significant alteration in the legal landscape. But it'll just be a one-line order, and that if you're not in the court and if you haven't been following the proceedings from inside, will be harder to decode. I'll give an example of this, and I discussed this in the book, and this goes back to 2019. A series of proceedings around the Land Acquisition Act that ended with a 5-judge bench decision that laid down a certain position of law that overturned 10 years of consistent doctrine. And to get there, a very unconventional path was followed, to say the least, leading to a situation where when that 5-judge bench sat, one of the strong claims made was that the judge heading that bench would recuse himself from hearing that case. And the judge said no, and then you have a final judgment that analyzes that argument. And if you just read that final judgment, it'll seem to you to be quite reasonable. This is a concurring judge who writes it. He analyzes the English common law on recusal. He analyzes the US law on recusal. He analyzes the Indian law on recusal, and says that on the basis of this doctrine, we see no reason for recusal in this case. And if you just have access to that judgment, you will think to yourself, oh, this is reasonable enough, or at least it's a situation where two views are possible. Except that if you knew the history of how it got there, you would know that this is effectively reverse engineering a completely indefensible conclusion. Right? And for that, you have to be there, and it shouldn't happen this way. And I say it in the book, it shouldn't be the case that I need to be in the corridors of the court, that I need to be in, at that time I was in a senior's chamber who is in one of those cases. Therefore, I see what's happening literally in front of me. It shouldn't be that way, but it is the way that it is. And that's why there is something in the critique of the court that requires physical presence in a way that is something unique about the way that we do things. And as I said, it shouldn't be the way, but it is that way. And that leads to, I think, certain pathologies as well. So, the candor and all of that, which Justice Muralidhar mentioned. I mean, the flip side is that then you end up becoming a gatekeeper yourself, right? As an attempt to get around the gatekeeping of arcane legal vocabulary and the procedural labyrinths that lead to a final judgment. When you take upon yourself the task of saying, I will decode this, then you become, in a certain sense, a counter gatekeeper. And then that, of course, has its own problems, because then you are taking me at my word when I say that this is the way it happened, and this is why it's wrong. And I think there is no way around that but to acknowledge in the opening that these are my biases. This is where I'm coming from, and take it as you see it and account for those biases. I think the other problem, of course, is that no matter how hard you try to be objective in analyzing the court, the moment you're in a case, you do develop a certain kind of attachment with the outcome you think is right. You could well be on the other side, and then you would be equally, I think, fall into the trap of believing your side was right. But it is difficult, especially in constitutional cases, not to become attached to thinking that this is the right outcome, the side I'm on. And that, of course, then colors the way you see a judgment against you. And as we all know, the side that we are on, judgments are almost always against us, right? So these days. So then obviously you tend to become, there's a cycle where you become angrier, and then the next judgment goes against you, you become even angrier, you try and become stay objective, it doesn't work. So I think that is also a problem. So, which wouldn't be the case if you were outside the court, because then you could at least, you wouldn't have that feeling of, I worked so hard on this argument, crafting it for so many days, look at how badly it's been treated, like by the judge, clearly like there's something off here. That wouldn't be a problem you come with when you analyze a judgment. So I think that's, again, it's a problem, and that's a problem that I think runs through the book, and again I think it's important to acknowledge that. Last bit is the tone. So there's often been this question about, is the tone too harsh and is it too critical? And one thing that I've experienced in engaging with judges, and Justice Muralidhar can tell me if I'm right or wrong here, although it's not said specifically in so many words, but the sense that is that there is a certain set of very difficult positions that judges find themselves in that you can't understand if you're not a judge, and that requires many compromises, negotiations, and things that need to be done, but which obviously can't be said in the final judgment. Something that is specifically true when you have the judiciary facing up or facing down a very powerful executive, whether it's here or anywhere else. And so that, I think, there is a sense that some of the harshness is unwarranted because you don't have access as a critic to the genuine difficulties that judges face. And I think that's correct, that judges do face difficulties that we don't and we can't understand. And that would require them to make compromises with respect to what they can do and the space that they have for maneuvering as a judge in the broader political atmosphere. So I accept that. And I think at the same time, the key thing to understand is that line of that political space is always blurring and shifting. And I think that one reason why a certain kind of criticism that might appear harsh is necessary is that while the executive and the state has the tangible power to get things done and to apply pressure, all that the critic has is the pen, right? And so sometimes you need to speak in certain ways to even slightly balance out that imbalance in power and try and shift that line of what is possible one way or the other. So in that sense, if the criticism at times feels strong or harsh, it's not because it's meant to be harsh, but sometimes if that is the only weapon you have to use it as strongly as you can to try and mitigate that balance. So I think these are my 2 points in opening, and you can go into the second round.
So yeah, just for the second round, I just want quick questions from you, because this whole business of position, I think it's a very important thing that you discussed in detail. To what extent has this telecasting court proceedings resolved that? Can people who are watching it feel as positioned as you would inside, or has that helped or distorted it? I mean, just very quick thoughts, because it's such a radical shift from what was, to have all the proceedings put out.
Not all.
Not all. Okay. So does that help?
Actually, live streaming, at least in the Supreme Court, is only of Constitution bench hearings so far. They're not of the smaller benches, and they're not of the miscellaneous days. In fact, you will have several heart attacks all over the country if people watched what happens on a miscellaneous day.
But has it helped the limited amount to which it's been opened up? Is that?
No, that is a good thing. See, I think constitutional questions, I remember hearing Professor Mohan Gopal in that EWS. And I think those kind of moments, if the whole country watches, it sets you thinking on ways of presenting. Like you have the same-sex marriage case. You could see a whole array of seniors and sometimes non-seniors also, present cases quite effectively. So it's also a lesson in advocacy, apart from also getting to know how judges react and which judge speaks what. So that, when we heard the NAS Foundation, a small booklet was brought out. I don't know whether you were privy to, you've seen it, where they actually sat and, noted on all the comments that both Justice Shah and I made during the hearing, what questions were put to the counsel, how the counsel answered. The entire thing is in a small booklet. Now that's possible with the live streaming, for people to actually watch what is happening. So it is definitely an opening up. But there is also this thing of, performing. So you will have performative lawyers and performative judges. And that's again inevitable in this kind of a process. But I think this is interesting. It's going to be an interesting way of looking at the court. I think this should hopefully not get reversed. Because I must tell you, the US Supreme Court doesn't telecast its proceedings. It only allows audio recordings of the hearings. And I remember Justice Kennedy and some other judge going up to the Senate and arguing why it should not be telecast live. So there are different positions on these things.
So shall we move into round 2, where Rebecca, we come to you again for your thoughts.
Yeah, so I think we've distributed this amongst ourselves, and I will be speaking on UAPA. Gautam spends quite a bit of the first part of his book on discussing various judgments on UAPA. And I'd like to start this by quoting from the book. I think he himself is relying on his good friend and partner in crime Abhinav Sekhri's article, but I will quote it. Where he says that the UAPA almost entirely stacks the decks against an accused. Going into a UAPA bail hearing, the accused's counsels have to argue as if they are participating in a swimming competition with both arms tied behind their backs. They cannot deploy any part of the arsenal open to the defense team in a regular criminal trial. And they're only permitted to try and point out internal contradictions within the prosecution's case, or show how, even when you assume the prosecution's case to be true, it does not meet the UAPA threshold. The Supreme Court's judgment in Vatali effectively tied a dumbbell to the defense's legs, in addition to its arms being tied behind its back, when it further restricted what materials the court would consider in a UAPA bail hearing. What is a problem with UAPA? I mean, there are many problems. Of course, the whole act is problematic, but essentially we can zero in on two statutory provisions. Section 43, which allows the custody of an individual to be extended from 90 days to 180 days before the charge sheet is filed. And 2, Section 43D(5), which places restrictions on the grant of bail. 3, of course, is a judgment which our man here passed while sitting in the division bench of the Delhi High Court. It's called Zaroor Ahmad Shah Vatali, which was like an albatross around our necks, and we could not get any bail subsequent to its reversal in the Supreme Court. What the Supreme Court did in Vatali's case was essentially 2 things. The Supreme Court said that once the prosecution places its charge sheet and materials, it is presumed to be prima facie true. And it was up to the defense to prove that it was prima facie false. 2, it said that there could be no probative examination of those materials, and criticized the Delhi High Court judgment for entering into a mini trial, while itself going into a mini trial while dismissing the findings of the Delhi High Court. So everything that was said in favor of Vatali was reversed by the Supreme Court holding a mini trial. Vatali effectively prohibited many accused persons from approaching the court for grant of bail, because that was a very, very high threshold to cross. Gautam, in his book, it's very interesting. He started with the Safura Zargar bail order passed by the trial court, and he says that when you read the order, a reading of the order makes it clear that insofar as both the law and facts stood in favor of bail, the court got around the first barrier by replacing the legal doctrine with a metaphor. What was the metaphor? When you choose to play with embers, you cannot blame the wind to have carried the spark a bit too far and spread the fire. It was a metaphor of its own invention, and vaulted the second barrier by replacing an accounting of the facts with a set of adjectives: unprecedented scale, inflammatory speeches that spared it the necessity of an explanation. Now, of course, eventually Safura Zargar was granted bail by the High Court on medical grounds. The other case he examines, which is very current, is the Delhi riot, is the judgment of the Delhi High Court in 3 matters: Asif Iqbal Tanha, Devangana Kalita, and Natasha Narwal. The Delhi High Court, in a bench headed by Justice Mridul and the second judge being Justice Bambani, granted bail. Justice Bambani authored the judgment, and in what is a in what is a very, very important judgment, the Delhi High Court said that the gap between what an individual is accused of and the actual events cannot be filled by inferences or speculation. This matter went to the Supreme Court. The Supreme Court did not cancel the bail of the 3 persons involved, but passed a very peculiar order, in as much as the Supreme Court said that this judgment cannot be treated as a precedent, and this was done to protect the interests of the state. Now, the remaining bail applications in the Delhi riots case are still pending in the High Court. There has been a slight shift in the last 2 months with the judgment of the Supreme Court in Vernon and Arun Ferreira's case, where essentially the Supreme Court has re-examined the Vatali proposition and has come to the conclusion that you cannot accept evidence at face value. You have to have at least a surface level examination of the materials placed before you decide to deny or grant bail to a person. That is one. And in that respect, it is a step forward. It proceeded to examine the documents placed in the Bhima Koregaon case and stated that much of these has no probative value. In fact, they are hearsay in nature and must be rejected, and therefore the prima facie test is cannot be invoked against the accused persons. It also proceeded to uphold the judgments of the Supreme Court in K.A. Najib and such like cases, where the Supreme Court has said, notwithstanding the embargoes in the UAPA, the constitutional courts always have the right to grant bail to persons accused of offences under UAPA, and delay being one of the very important grounds for grant of bail. I argued the Vernon case, and I am very happy to concede that had Vernon and Arun Ferreira not spent 5 years in jail, I perhaps would not have got this order from the Supreme Court, because what weighed in the mind of the court was the fact that on such bad material, they were in custody for 5 years. I doubt whether such an order would have been passed in the first 6 months, because they hadn't done time. So this brings us to this compromise, which has been which the judiciary is now has brought out, where they ask what is the time spent. So if you've spent a minimum of 4 or 5 years, they're more inclined to grant you bail. But you have to go through that period of incarceration before they're willing to look at materials placed against you, even if those materials have no probative value. I will also say that the Vernon judgment, we were in the Supreme Court for 1.5 years before that judgment was passed. So we spent 1.5 years of the 5 years of incarceration arguing for bail in the Supreme Court. In round 1, we almost lost because we were sent back on the ground that let us see whether the trial court will frame charges against them. The trial court sent back a letter saying it is not possible to frame charges within the next year. After that, it was heard by another bench, and then, of course, this particular judgment came out. UAPA, therefore, and the other thing that Gautam, it's a very interesting case. He talks about a case which was passed by the Bombay High Court, a judgment passed by the Bombay High Court, Iqbal Ahmed Kabir Ahmed's case, in which the Bombay High Court had relied upon the judgment of Shreya Singhal, and this was the argument of Mihir Desai in that case, and based on that on Shreya Singhal's judgment, the Supreme Court decided to grant bail. The state came in appeal the Bombay High Court granted bail. When the state came up in appeal, the Supreme Court, in a bench consisting of Justice Chandrachud, did not revoke the bail order, but said that it was unnecessary for the High Court to advert to the decision in Shreya Singhal versus Union of India, and the judgment of the High Court can be sustained even independent of the said observations. So there is this hesitancy. Devangana, Kalita, Natasha Narwal, Asif Iqbal's bails have been preserved, but the bail order of the Delhi High Court cannot be treated as precedent. When the Bombay High Court in Iqbal Ahmed's case decides to grant bail based on Shreya Singhal's judgment and an argument made therein, the Supreme Court says that you will not advert to the decision of Shreya Singhal, and the judgment of the High Court can be sustained on independent observations. As it stands, there are a bunch of 9 petitions pending in the Delhi High Court in the Delhi riots case, which have been pending for the past year and a half. And no order has been passed even now. I think when the Supreme Court says that bail applications should be heard in 2 weeks' time and decided within 2 or 3 weeks, and when you see the court sitting on cases for a year and a half, what is the message you're trying to send out? If this was an ordinary case where there was no chakka jam, or as the allegations say, there were no speeches against NRCCA, it is very likely they would have got bail many, many months ago. But because there is UAPA attached to the charge sheet, they continue to be incarcerated on little or no evidence. And unless the High Court decides one way or the other, we cannot go to the Supreme Court. So this is really the tragedy of persons arrested under UAPA. There's a little interesting nugget in the end where Gautam talks about a particular judge who passed, and I won't name him, who passed the judgment in Asif Iqbal Tana's case and then passed the polar opposite judgment in Umar Khalid's case. And he ends by saying that it is one thing to have a polyvocal court that speaks different tongues, although that is problematic enough, but it is quite unheard of to have a polyvocal judge. We can perhaps only shake our heads at this marvel and agree with Hamlet when he wisely says, "There are more things in heaven and earth than are dreamt of in your philosophy." The UAPA section is fascinating. It's a must read. The analysis is fabulous. I think perhaps in the next book you could update put in the Vernon judgment and the shift from the traditional Vatali position, and hopefully that judgment will help those who are in the Supreme Court, Umar Khalid and others, to get bail. Because even, Umar Khalid's case is quite, although it's pending in the Supreme Court, there's really, as you know, no evidence of any terrorist activity for which this act was originally enacted. Yes, what Gautam teaches us through these chapters is that we've forgotten the basics of criminal jurisprudence while analyzing cases under UAPA. We fail to look at the materials produced by the prosecution in any robust way, and it is always easy to fill in the gaps that the prosecution has left open by drawing inferences and surmises that are not sustainable in any manner. Thanks.
Jasmine, would you like to go next?
No.
For
please.
a change. Go ahead, please.
Okay. So I'm going to depart from what we decided that I'll speak on.
Oh, you are?
Yeah, which is
Well,
why
you
I
have
think.
to go. That's like, okay.
Yeah, so you go ahead and then.
No, you go ahead.
So I wanted to answer Gautam's very pertinent question, what transpires in the court and the difficult positions that judges find themselves in, and how they have to negotiate these spaces. So I must begin with a humorous anecdote, because I think there's some humor called for in this audience. There was this judge who was appointed to one of the high courts. He had been a district judge, and then he was elevated as a high court judge. And many of them, actually, I don't know how many of you noticed this, many of them who get elevated from the district judiciary to the High Court rarely get more than 5 years to serve in the High Court. You can have judges serve in a High Court for even less than 3 years. It's a fact. So anyway, just judges for a short tenure. And as Gautam points out in this book, I mean, it's a facet of the function of the Supreme Court itself. The senior judge dominates the entire proceedings. The other judge is actually sitting quietly and hardly interjecting. Of course, there have been notable exceptions to this, one of them being Justice Rumapal, who I think from the first day was very vocal and very assertive. So this judge just sat there, agreed with the senior judge, and it was close to his retirement. It was just 1 month away from his retirement. So some of his friends called him and said, does it look good? You've been a High Court judge. Look at the reported cases. There's not a single judgment attributed to you. And why do you have to agree with everything that the senior judge says? Disagree in some judgment. So the next time this judge was given by the senior judge the draft in his chamber, he wrote on that, I disagree. So sent it back. The senior judge was actually quite happy. He said, he called him, I'm very happy to see that, you've said you disagreed. So, please give me the reasons for you disagree. He says, I wasn't told that I was supposed to give reasons. Oh, sorry then. He scored it off and said, I agree. There's a lot of negotiating that happens in the Constitution bench in the Supreme Court, which we are all not privy to, but we can kind of, when people watch the court closely, can find out what happened. In fact, there are 2 judgments here, in this period of 2013 to now, which Gautam doesn't talk about. One is the NJAC judgment, okay, which we saw a lot of negotiating going on between the bench and the bar. And he also doesn't talk of the Ayodhya judgment. So, Gautam will have his own reasons for that. But the point I'm trying to make is, there are judges in a constitution bench who will come out with a draft first. There are judges who have writer's block. Believe me, although we have a profusion of judgments coming out from the courts, there are some judges who have a writer's block and can't immediately just produce judgment. There are some judges who are beginning to write the judgment even as they're hearing the cases. So you can easily make out when you read those drafts, which are the judgments that have come out first. What could happen is, and if you read Gautam's book carefully, you will know which cases I'm referring to. If the judgment that comes out first, the draft that comes out first, is actually going to be the dissent, then the majority has to get its act together very fast. So that you will find at least in 2 instances here, which is why the majority judgment was all slipshod and had a lot of errors and which had to be corrected, which Gautam is aghast about. But I can understand, you have to pronounce the judgment because let's say one judge is retiring. You have to pronounce it on that day. And you trusted this one judge to actually be the majority judgment. You get the draft and say, oh God, I can't agree with this. So I have to sit and now entrust it. Either I write it myself as a presiding judge of that bench, or senior judge of that bench, or call upon someone to say, come on, you better write the majority. So there are at least 2 instances which you will find when you read this book, that the majority judgment was written very hurriedly. So that negotiating probably didn't work. The judge who wrote the dissent was not able to convince. I'm told Justice Jeevan Reddy was a judge who always came out with the drafts first. He was able to persuade, and this is the American style. Frankfurter is known to be a judge like that. In fact, there's a humorous anecdote about Frankfurter. Frankfurter came out with this judgment, and they sit en banc. The Supreme Court in the United States sits en banc. And one judge was refusing to agree with Frankfurter's, but till he gave his dissent, they couldn't pronounce the judgment. 1 month went by, 2, 3, and then the majority got perturbed. Frankfurter then went out to the chamber of that judge. He says, what's your problem? He says, I just can't find the time to write. So Frankfurter says, you have your notes? He says, yes. Give them to me. So there is this written about that Frankfurter wrote the dissent as well in that judgment so that the judgment could be pronounced. That was the brilliance of the man. So there is a lot of negotiating that takes place within the court, and you'll find those compromises, uneasy compromises made. You'll find this phrase used by many senior lawyers, including Becky here, operation successful, patient dead. So many cases, like I can straight away think of Menka Gandhi one. Olga Telles, you will have phenomenal pronouncement of the propositions of law, but the actual relief will not be there. I'm told that's the same of, you must have written something on the Shiv Sena judgment.
No, not yet.
Not yet. Okay. So there are, you have. No, so the judgments will lay down the principles, the legal position, but in terms of actual relief, you'll find, it peters off. And then, of course, you have the fait and comply positions. You're going to find a series of those fait and comply positions now. Because, like what he talks of is judicial evasion, where cases are unable to be listed and unable to be decided when they should have been decided. So I was chatting with Gautam just before this book, and I have my own scenario of what ifs. I don't know how many of you have seen the Black Mirror episodes. Some of you have. One of the last episodes is on episode titled Bandersnatch. It actually takes you to a scenario and asks you as a viewer to choose. Do you want this character to do this or to do that? If you want the character to do, let's say, jumping off a cliff, right? He's going to commit suicide. He jumps off the cliff, and then what happens? The story takes you in one direction. He decides not to jump off the cliff. He comes back. The story goes to a different direction. So there are many such what-if moments in the Indian judiciary. And I can start right at the beginning with Justice Krishna Iyer, listening to the stay application argued for Indira Gandhi by Nani Palkhiwala. What if he had not granted the stay on that day? What if the Supreme Court, as a 5-judge bench, which included Justice Khanna, did not reverse Justice Jagmohan Sinha's judgment invalidating her election? They actually upheld her election. So what if? There are so many what if moments, and many of the cases that Gautam is talking of in this book have many of those what if moments. So if you sit back and reflect, what if the court had done this instead of that? You'll have a fascinating story by itself to say. So one more reason why you should be reading this book. The flip side of this whole blog writing within a few hours, writing on the same day, is that I don't know if Gautam has had an occasion to revisit what he wrote. This book apparently is all his blog writings as they were written in the first instance.
There's some...
Okay. So see the editorial. The minute something is in print, editorial decisions come in.
There were five deletions.
All right. But the thing is, in other writings, and this is what I asked Gautam, he can answer when he comes back to us on this. You will have someone trying to correct you, saying, listen, there is another perspective. Maybe you missed this out. Maybe you got this wrong. So you have an exchange. Many of the writings you can see when they are published finally, they'll say, though, I wrote this first, I got this reply. My reply to that was this. So you get a development of that whole position, which I don't find here. So I just want to know what your process is when you get feedback on. I mean, not talking of comments below an article. I mean, all those comments are best ignored because many of them have nothing to do. And, LiveLaw is here, and I'm sure Baran Bench is here somewhere. They are all the time trying to control, what happens in that comment space. But as a writer, this right of reply, do you follow that kind of a system or not? That's something that I would be interested to know. Before I'm sorry, I think overshooting. There's a very interesting concept that Gautam has added to our discussion on PIL. He calls what is called a fourth phase PIL. This is something we've all thought about, noticed, but haven't been able to articulate it the way Gautam articulates it. He says, I define fourth phase PIL as follows. The use of the court as a vehicle through public interest litigation and the procedural and substantive flexibilities that it allows to restrict or curtail individual rights guaranteed under Part 3 of the Constitution and or to achieve political goals that are blocked by normal political routes and or to stymie existing legal proceedings or bypass statutory processes. I think it's a very important addition he's making to the debate on PIL. How PIL could have been used, and used even by states and by governments, to legitimize what could be questionable action or to actually change the political discourse. There have been many such PILs in the history of the judiciary that have changed the political discourse in the country. The earliest being the fodder scam, the 2G. I mean, I can just think of such, one or two instances where the whole political discourse changes because of one such, event happening in the judiciary. But again, fascinating read, much to think about and talk about.
Thank you. So just before we go to Gautam and then he can take question and answers, just a very short point on something that the book really drove home. But before that, I'd like to just read out a bit, which is very interesting. It's a conclusion on one of the Chief Justices that he reviews. As you've noticed, we've all done the opposite of what Gautam does. None of us are naming the judges. Gautam goes ahead and names them. So I won't name the judge either. It says, it's not easy being a Supreme Court judge. It is specifically not easy being a Supreme Court judge in the time of an absolute majority government whose approach to the Constitution is like Douglas Jardine's approach to the Bodyline series. Stretch the rules to their absolute breaking point and see what the umpire will let you get away with. It is reasonable for critics to temper their expectations of the court at times such as these and to appreciate that as a political actor with limited political capital, the court will have to negotiate a space for itself, and that negotiation will often require a degree of compromise. But while one can sympathize with the difficult position that the court finds itself in, what is disappointing is that when it appears that the court is not even trying. So I come to the idea that I got, this is a whole door that Gautam's book opened to me, actually the blog when he first wrote it, on to what he calls a doctrine of an unconstitutional state of affairs. So he discusses it in particular in the case of the demolitions that were happening, the home demolitions that are happening, dime a dozen, about courts, which apparently there is this, the Colombian court in 1998 came up with what it said. It concluded that this was an unconstitutional state of affairs prevailing in the country. So the courts had to not just view it like they're locked up in a room with the defendant and the prosecutor, but to see the larger context and to be able to decide that in the larger scheme of things. It's a very serious conclusion the Colombian court would have come to, a constitutional court. It is something that the Brazilian court does also in 2015 when it realizes, and Gautam quotes on what exactly is an unconstitutional state of affairs. The unconstitutional state of affairs is a legal ruling that allows a constitutional court to acknowledge the failure of both the legislative and executive branches of government to enforce public policies against widespread and systematic violation of fundamental rights. And it goes on. So my proposition is that maybe we're right. After reading his book, I'm of the firm view that the Indian courts, our constitutional court, would like to consider the very own South Asian, or certainly the Indian version of how to have a doctrine for an unconstitutional state of affairs. Whether it comes to how the executive sort of behaves, whether it comes to how institutions behave, whether it is demonetization, whether it is suddenly making Aadhaar a compulsory thing where it starts off as a voluntary thing, whether it comes to, I hate to be the dark shadow when Rebecca tried to shed some sunshine when you spoke of the good things that may have happened 2 months ago with bail. But what we're watching with bail, we're watching lawyers, intellectuals, people who are behind bars before even substantive trials or charges being framed. We found Stan Swamy dying because there wasn't a sipper that he could be provided. So it is my belief that we are unfortunately getting into a state where there may be a good case for the judiciary to come up with its own doctrine of unconstitutional affairs within which things could be seen. But I'll end with a slightly, I hate being like this gloomy type. I like to see myself at Pangloss. But what worries me is that, and this is where the whole gradient of cases, as we've heard, is that I hope the judiciary itself is able to escape being not part of that unconstitutional state of affairs. So I'm just one, like who will judge the judges kind of a proposition. So, but I would think that the one takeaway for me, and the most stark one for me, has been this doctrine of unconstitutional state of affairs, which I really think we should be thinking of. Because I think, Gautam, and thank you for writing this, because it opens up our heads and minds and eyes to so much more than just the courts. So over to you to kind of respond and then take the Q&A.
Yeah, I think that was interesting because one thing that Latin American courts have been good with in a way that other courts are sort of yet to catch on to is this systemic analysis. So there's also this very famous judgment with respect to the FARC guerrillas and sexual violence during a time of internal armed conflict. And then they look at it as a structural issue and then issue remedies. And the problem is that Latin American court judgments are in Spanish and they're not translated. So there's a whole continent that's walled off from us because we can't access their judgments apart from what trickles through. But I think with respect to what the court can do when it looks at a problem, so I mean the issue with home demolitions, and I'll so just briefly flag that and then sort of come to my final comments, is the way it happens is that there is a home demolition that takes place after a violent incident, as we all know, and then the state acts in this two-faced way, right? So on the one hand, the the municipality and will formally say that this house was built illegally or unregulated, encroached. That's why we're demolishing it. And as we all know, 80% of our urban landscape is an encroachment. So they'll say that. Meanwhile, the politicians will signal that this is obviously a revenge demolition. And when it comes to court, the court has this problem that it can't really, unless you have very striking evidence, it can't normally go behind and say a mala fide state action. So it'll have to sort of take the state at face value in that it'll examine the law around encroachments and regularization and so on. So that's sort of the court gets hamstrung there. Something like this doctrine where you have demolitions happening over months in like multiple places is where the court can say, look, once, twice, thrice, how many times will you somehow always, demolish just after this in this way? So I think that's a use of a doctrine like that, and I think Latin American courts are instructive in that way. And I hope that that they'll become a part of our discussion, because we do look at the US a lot and South Africa a bit, the UK, and that's a place where we could look to for many interesting things. So a couple of points. I just want to end by speaking about judges a little bit, and I think that this issue, a few, I think, again, pathologies about the way we, I think, engage with or understand the judiciary, because the substantial part of the book obviously is about that, and that is that judicial ideology is a reality, and we need to acknowledge that. And I don't mean ideology in the cruder sense of your political ideology, because of course we all have that, but just the question of how a judge approaches state power, the degree of skepticism that they bring to the state power and the state's claims, and things like that. That's a very real thing, and every judge obviously has that, and that plays a role in how they judge. Now, in some countries like the US, you formalize that, right? So it's like a spoil system where the winning president nominates the judges to the court. Nowadays, assuming that the Senate clears it, which is also, of course, quite partisan now, that judge will be that president's appointee and will, in a certain sense, of course, subject to surprises from time to time, reflect the ideology of that president and that party. Right? And that's why the US Supreme Court splits so often along party lines, and as well as the other courts. Now, I don't recommend that model. I think it's pathological in a way that's much worse than ours. But there is that honesty in acknowledging that judging is a political act, and that is a political actors, right? So there is that. I think that the problem that we have is that we just completely in our discourse refuse even the possibility of that existing. And so one thing, and I think that in all the discourse around the collegium, I think one problem that is not really focused on is that one thing that the collegium system does is it feigns depoliticization of a political process, right? So if you look at what the collegium resolutions say, it's always so and so, and this is very bland sort of resolution, which will be is meritorious, is from this state, that state doesn't have representation in the Supreme Court, is seniority wise so and so and so and so, thus giving the impression that what is happening is this completely depoliticized process, and thereby also leading to the conclusion that judging, is a depoliticized process. You're all applying the constitution, applying the law, and judges are essentially interchangeable, right? So it doesn't matter who the judge is, because it is effectively a depoliticized act. I think that's a dishonest conversation, and that leads to, again, just an unhealthy discourse around the judges, because we all know that's not the case, right? And lawyers in the audience will know that literally the first thing you look at when the case you're doing is listed is who's the bench, right? And I remember some of the lawyers here will also know specifically back in 2016, and for once I will not name the case or the bench, we wanted to file a quashing of an FIR which was political, completely outrageous. First thing that the lawyer told me was that check the criminal roster in the High Court, and so I came back with these are the 4 benches who are sitting on the criminal roster. He said, we're not filing this quashing. Like, we'd rather not file it and not get a dismissal than file it and get a short dismissal, right? So I mean, the point is that we need to find a way to acknowledge that. Now, again, you don't need to have the American system to do that. For example, and this brings us back to the collegium, I remember once following South African confirmation proceedings. So they have a Judicial Appointments Commission, and the journalists can sort of follow the hearings and the interviews. That they conduct interviews, right? And so journalists sort of report and follow and live tweet the interviews. Same thing in Kenya and other countries. One question that they asked every aspirant to the Constitutional Court was, name a judgment of the court you disagree with and would overturn if you got the chance, and give reasons. Right? And I remember that the first aspirant named a judgment called S versus Jordan, which is a fairly conservative South African judgment on sex work, right? And then gave reasons. And through that, you immediately got a sense of where he's coming from, right? Where he or she is coming from, how they perceive state power, how they perceive when the state can regulate and what it can't regulate. And then that gives you a sense of, okay, this is who they are as a judge. And fair enough, they could be conservative, they could be liberal, they could be radical, they could be a judicial conservative. All of that is fine. That's the par for the course, and a balanced court arguably should have, all those judges with these ways of approaching the Constitution. But that has to be a public conversation, right? And so therefore, what's happening now is, when in a bail case, the Supreme Court, when the bench is announced, right? In our WhatsApp groups, we're like, oh, right, okay, yeah. I mean, we know what's going to happen, right? For both ways, like whether the bail will be given or not, we're like, okay, yeah, clearly this is what's going to happen. And it always happens that way. Unlike the American Supreme Court, where you do get surprised sometimes, there's ironically much fewer surprising outcomes in the Supreme Court with respect to things like bail and so on, because it's like, there's less scope for surprise. So I think that one thing I would want to sort of maybe end on this note is that conversation about judicial ideology and how it impacts judgments needs to be a public conversation, not an underground conversation in WhatsApp groups between lawyers, right? So we need to start by saying, look, these are the various strains of ideology, in the court with respect to criminal law or tax law or labor law or constitutional law. These judges are exponents of that ideology, and that's how it reflects in their judgments. And so therefore, when the Chief Justice assigns a case, there is a public conversation about, what that means, and not a private conversation about, not again, right? So I think that, I would close on that note. It's important because of the succession plan. Do you want to?
Yeah. Also, what he's saying is important because we have what is called a succession plan in the Supreme Court, where you make a deliberate choice of who's going to be the CJI. So I think what he's saying has, that.
And the CJI, of course, just to reiterate, is the person who selects the benches. And when you have a court of 34 judges with panels of 2, that turns into, from what was originally a procedural or administrative function or role, into a very substantive role. And again, the reason why we can't speak about it, publicly is this overarching idea that judging is depoliticized, right? The moment you start acknowledging that choice then becomes one thing you can scrutinize and have a conversation about, right? So I think we have some time for.
So just as an interesting snippet, I was once asked to go to the Allahabad High Court, and I asked my briefing counsel, what is this judge like? So he said in Hindi, अच्छा भी है, बुरा भी है. So I said, what does that mean? He said, हाँ, दे भी सकता है, नहीं भी दे सकता है. So, and then I said, all right. And then he looked at me and he said, वैसे वो औरतों को कुछ नहीं देता. So I said, why are you taking me? What do you want me to do? He said, नहीं, आप चलिए हिंदी में बहस कीजिए, अंग्रेजी में नहीं. जो औरत अंग्रेजी में बहस करता है उसको कुछ नहीं मिलता है. So I actually argued as much as I could in Hindi. I wasn't entirely successful, but I wasn't thrown out of the court. So yes, you're right. When we take on briefs, one of the first questions I ask is, who is it before? Because you need to know your court before you know your brief. So that is very important. Gautam, do you want to open the floor and take questions?
I think we have some time to do that. And I think so the way we discussed it amongst ourselves was that the questions, just address them to me, and then, based on the question, I can pass them around. Just the necessary sort of filtration, so that, so that we can open the floor.
Yeah, and one more caveat, questions should be questions. sometimes you launch into an opinion and a position and then it gets long and winded. Yeah.
Congrats on your book, sir. It's very nice. Sir, one thing I wanted to ask about is that have you talked about persons with disability, judgments pertaining to persons with disability? Because we are an invisible minority, very less is talked about persons with disability. Let's say even in a judgment where beyond 50% of disability, a visually impaired person cannot be allowed to become a judge. That judgment was highly criticized in the public, but a very less is known about that judgment in the public domain. Similarly, sir, very less is known about defense, and very less is known about lower courts. Some of the good cases are not even being able to go to the High Courts and Supreme Court also. Like with my own case, as a person with disability, my wheelchair was not allowed to go to the Gurdwara, inside to go to the Gurdwara, because it's no, they don't allow, because they don't have any logic or anything. They said it's dirty, and so I filed a case for Chief Commissioner for Persons with Disability. Now when I filed the case, they listened to me. They said, oh, nothing doing, there should be a ramp and you should make it necessary. But when the judgment came, it was all sympathetic. That person with disability, spirituality is the source of strength for them, if possible. There is completely the paradoxical view in the judgment. So these kind of judgments, now it's very difficult for anyone to go to all the way for Supreme Court and then wait. So have you analyzed the lower courts and higher courts? Because it seems that you have overemphasized judgments of the Supreme Court in your book, as it seems to me. I have not read the book. Thank you.
Take maybe 2 or 3 and then put them together. Yeah.
Yes.
Anyone? I mean, it's just like yeah. Anything?
Thanks for coming out for this book. It's always a delight to reading your work. In your book, when you are looking into judicial approach to UAPA in the first part, particularly when you talk about flurry of phone calls in Umar Khalid bill petition, it's in page 43. So for me, it looks like the interception of phone communications based on CDR or phone tapping seems to be a guilt of communications, as this communication itself is enough to show the conspiracy and thus denying the bail petitions in UAPA cases. But there is an exception if we look in 2021 Akhil Gogoi case, in Chandbari and Chauba case. The Special Anayat Court said, after examining both CDR and phone tapping, it held that mere exchange of phone call to organize protest does not lead to conspiracy. What's your observation on that?
This one behind.
I'm going to defer to you on that one. Yeah.
Hello, good evening everyone. I'm Ankush. I'm a lawyer working in Delhi. My question is for Justice Muralidhar. So this book primarily covers the last decade that has happened, and we have seen in India in general that whenever there is a strong legislative government power, courts, institutions bend to that power. So my question to you is that what sort of institutional things, what sort of structural changes we should think about in the context of courts so that this does not happen, and is there any observation beyond appointments, post-retirement appointments, and those things which primarily what I have written and read about is the things that influence court decisions in such a time where there's a lot of legislative power.
So on disabilities, there are 2 things. One is that there's a case involving reservations in the context of disabled persons that's discussed in the book, and that's there. Otherwise, there's not too much, because I think you're completely right in that there is a bias in the book towards the Supreme Court and to an extent the higher courts, which is a function of just where I am located. So mainly I happen to be there, and it's just much harder to keep track of trial courts and how they proceed. So in that sense, yeah, I mean, it's that's a failing of the book for sure, and hopefully it's something that someone else can make up. I think but I think one thing we're seeing is that there is perhaps a gradual evolution of the jurisprudence, at least in the high courts, with respect to understanding disability as a source of discrimination and remedying that. It's still, I think, in the very beginning, you don't find too many cases. You do have the Jija Ghosh case and the airplane case and all that. I think it'll take some time before the courts are adequately equipped to examine those cases in the correct lens. I think it's begun. That jurisprudence has begun recently. I think I'll defer to Rebecca ma'am on the UAPA phone calls question.
Firstly, I'd say, every criminal case is decided on the facts and circumstances of that case. So I don't think we can compare two cases in that respect. But this flurry of phone calls is, of course, a very prominent part of the UAPA charge sheet in the Delhi riots case, where they said that a flurry of phone calls after the riots had started between activists who have been engaged with the issue in question is indicative of a conspiracy. I obviously disagree, but you see, in all these cases, at the end of it, you have to marshal the evidence. You have to find out what constitutes a crime. Just because a few persons have called each other, I mean, it could even be evidence of concern. Why is it evidence of conspiracy? But more than that, I think the question that we must ask ourselves is how investigating agencies use phones, electronic items, and seek to, I mean, the first thing they do after a raid is seize your phones and seize your electronic gadgets. Literally your whole life is with them. And I think the time has come when courts should come down heavily on this practice. I have argued in the past that at least a Section 91 notice should be given to an accused person who can contest the admissibility of evidence of this kind. We have seen in the Bhima Koregaon case that there is a counter report which has come, which says that all of these electronic evidence has been fabricated and therefore cannot be relied upon. So more than whether phone calls constitute an offense or not, I think the important question is the use of phones and the use of computers, where your personal life is used to portray you as a criminal. I think the time has come when we should protest against the compulsory seizure of phones without court orders.
I think our friend Abhinav is in the audience somewhere, been nodding furiously at that, given how much work he's done on that. But just to add one point to that, in the this flurry of phone calls in the Umar Khalid bail order plays a big role. And when I read both the trial court and the high court judgments, that seemed to me to be in the facts of that case, one of the most illogical aspects of it. Because if you think about it, if you are an activist and you have a group of activists, and riots take place that involve your community, the most natural thing in the world is to start making phone calls, right? Like, what's happening? Is someone hurt? Does someone need to go to hospital? Where do we go to help stop this happening? Activists calling each other after a riot is normal. Activists being silent suddenly, it would be the abnormal thing. But that somehow is used against Umar Khalid in that bail. Yeah, among the many absurd things in those orders, that was, I think, high ranking for me in the hierarchy of absurdity that's there in those two orders.
I wanted to answer your question. Gautam has a whole chapter on High Court judgments. That is 3 judgments the Delhi High Court he covers, and then he very importantly covers a judgment of the Manipur High Court, when Justice Sanjay Kumar, who's now in the Supreme Court, was the Chief Justice there. And the case was Nandita Haksar versus State of Manipur about Rohingya refugees not being permitted to travel to Delhi to apply for the UNHCR refugee card. So he has, and he's also got a very scathing review of a Jammu and Kashmir High Court judgment. So there are High Court judgments scattered around the book. Just to answer that question, I was hoping, in fact, when we discussed just before this session, we said, we shouldn't take questions directed at each of us, but to Gautam. But as Gautam says, this question I have to take. But I'd like you, I don't know if you've got a copy of the book. In page 415, Gautam says this: for many years, there has been an established model to study constitutional courts in democratic republics, especially courts vested with the power of judicial review, as counter-majoritarian institutions that may sometimes succeed but often fail to check majoritarian impulses, as imperfect but important protectors of rights and institutions, and as institutions that, at the end of the day, are built on a process of open and public reasoning and deliberations. Now, this is the question that you asked has to be unpacked at various levels, but I must just respond immediately to that it's far from now, being a lawyer in the Supreme Court for 2 decades and now as a judge for 17 years, you begin to have more insights into the way the system is functioning. I begin to question how democratic is the bar itself.
Yeah.
How counter-majoritarian is the bar?
Correct.
If you look across you look at the Bar Council of India today, you look at the bar associations around you, how many lawyers believe in, the constitutional values of questioning power and authority? Now, the bar is literally, and it's not a cliched phrase, the bar is the nursery from where all judges are picked up. Whether judges for the district courts and the magisterial courts or whatever, all that hierarchy of courts, or judges for the Supreme Court and the high courts. So, if the bar does not imbibe within itself, doesn't believe, like within the bar, you will see that lawyers who appear in these kind of cases, literally you can count on your fingers, right? So, I'm just saying, this is something that we need to deeply reflect on. And to the lawyers in the audience, I want to say this, that if you don't start asserting democratic voices and ask for democratic practices in the bar, you can't suddenly expect the court to, have judges who believe in all those values and practices. So we have not talked enough about the bar is what I feel. In fact, there's another book that's come out, which is very interesting on the empirical study, the court on trial. So it does mention to a certain extent of how the bar controls the way courts function and think. This having to respond to majoritarian impulses. It's not just about the government in power. It's also the societal, pressures on judges. Many judges have told me how, they get controlled by how they're viewed, not just by the society in which they operate, even their own families. So the judge comes back and in the house he's asked, how can you grant bail to a person like this? So this is the kind of a thing that we work in. So I think we need to understand at that level, and then we can have a full discussion. It will take several days of discussion on this. Yeah.
But that just reminds me of something very interesting I recently read. I was reading a political history of Kenya after independence, and of course they had their 2 decades of authoritarian rule by Moi. And the interesting thing was that, and this sort of gave me pause, because at one point this historian is discussing the resistance towards the end of the regime, and apparently the biggest thorn in the side of Moi was the Law Society of Kenya, the LSK. And there was a journal called the Nairobi Law Monthly, and that criticized him and the dictatorship and all so badly that he had to finally ban it and detain the editor. So, you do have examples where the bar becomes a focal point of sort of, assertion of democratic values in the post-colony, not just the independence movement.
No, and Gautam talks about how lawyers as a collective body rose to the defense of the CJI on the master of the roster controversy. So this is the kind of court that the bar wants. This is the kind of a system that the bar wants. That's, one thing that he's trying to tell you in this book. And you must interrogate that. You must interrogate that. I think we should have more discussions on the role of the bar.
Just take the last two or last one.
Okay. Yeah.
There's so many for you. Chibber.
Anyone wants to?
Take Manish. Somebody who's standing.
Yeah.
There.
Back. Someone at the back.
Manish also.
Manish was standing. Yeah, the mic's coming.
My question is to just Muralidhar. I know we are supposed to, and maybe Gautam can also pitch in. we have heard you talk about give and take. What about the, if you could throw some light on the give and take between the members of the collegium in the High Court and judges of the Supreme Court, especially on judicial appointments?
We'll exercise some prerogative to just like talk about that after, not in the. Any questions not to do with like appointments, collegium, stuff like that, because of very obvious reasons. Yeah. Go ahead.
You spoke about the powers now in the blog. The powers of the Chief Justice are deeply scrutinized. The Supreme Court as an institution is deeply scrutinized. How bench composition, bench strength effectively determines outcomes. But is there a requirement for an alternative? Do we need to do away with the master of the roster system? Are there better alternative systems around the world that need to be utilized as a model for the Indian Supreme Court?
Oh yeah, absolutely. I mean, the master of the roster has to go. There's no doubt about that. Though I have no compunctions in saying that. No, so there are many other alternatives. One is a straightforward lottery system, right? Where the assignation. Okay, so just to take a step back. Reason why there is a master of the roster is because someone has to administer the court. Right? In the way it evolved is that you administer the court, and the court sits on bank, so bench of 15, and the bench of 15, say a bench of 15 judges, and 5 or 7 decide a case. So the discretion scope is much smaller. When you have 34 judges and then you sit in benches of 2, it becomes a much vaster discretion. That's why it's become a problem in India. Options include, for example, a lottery system where you assign cases on the basis of just a computerized lottery where it can go to anyone. You can take your chance with anyone. So that takes that power out of one hand, and in a certain sense makes it randomized. So your bail application, then depends on a lottery before which it goes, and not upon how the Chief Justice feels about your bail application or the registry for that matter, right? Because they also have a lot of power. The other is to again have a have a roster and stick with it, right? So, for example, if you look at some continental countries, the way it works is you wouldn't have a single Supreme Court. You'll have a Supreme Criminal Court, a Supreme Administrative Court, a Supreme Taxation Court, right? The idea being that if you come up with expertise as a lawyer or as a High Court judge in a particular field, then the roster gives you those matters, right? So if you have spent your life doing criminal law, then it makes sense that you would then handle criminal cases, right? So that is one other way. So there are many alternatives you could have based on what values you want to, I think, promote. But what you shouldn't have is the present system, because then it becomes one person, right? And it's too much. Not only is it too much pressure for one person, we shouldn't expect one person to handle that degree of pressure, but it makes an office attractive for capture, right? So when you vest all powers in one office or one body, it's attractive for the politicians to want to capture that, and you want to disincentivize capture, right? So you do that by distributing power and not by focusing it. So that's my view, unless any other.
No, actually it's more complex. When you go back to the Chief Election Commissioner debates, when they made the Chief Election Commissioner's office a multi-member office, I don't think it solved that problem by having more people wield that power, because there's something else to it. And so I think there are no easy answers to this at all. One possible answer is, even within that same roster, he talked of criminal court, right? Suppose, let's say, and 90% of the judges who've been appointed for their criminal law practice were all prosecutors. So they would carry those, and let's take even a labor law roster. Let's say I've been a management lawyer all my life. To expect me suddenly to sit as a judge and to be completely neutral is unrealistic. I may be very efficient in my taking up cases and disposing them off, but my bias will run through. So sometimes the labor bar is hoping that one of their colleagues is not sitting in that roster. So it's far more complex than what it seems.
One last question.
Are we done or?
Maybe just take last.
Okay, yeah.
Yes. Just one hand up. One hand. Just give it. Yeah. Yes, please.
Thank you. My name is Steve. I've been a long time reader of your blog, Mr. Bhatia, and especially of you, Ms. Chishti. I am a subscriber of the India Cable. I really look forward to your opinion, your editorial pieces every evening.
Steve.
Okay. Actually, I have a question of a more general nature. So if you could indulge me, Mr. Bhatia. So I've been keenly following your work on the blog. So I just wanted some insight as to how do you manage to, generate so much literature, which is, concurrent with the times. So it's literally current affairs for a nerdy reader like me. And how do you manage that vis-a-vis your professional life as well as your public image? Like, because you have a lot
public image.
Yes, sir. Since you're one of the most outspoken lawyers of our day, and I also follow it on Twitter, and I noticed.
I see you're going with that. Yeah, okay. No. So, well, two things, and I'll make this brief. As far as volume of work goes, a legal writing professor of mine once said that writing is like a muscle. The more you exercise it, the easier it is. The less you exercise it, the harder it becomes. You'll start spraining and tearing your muscles. So if you're writing every day, then it becomes quick and almost internalized. It's quite straightforward. So that's how it works. Public image, yeah. I mean, there's obviously an issue with respect to writing, about the court in which you appear and are frequently a participant in. And I think that the simple answer there is that you can be bold if you have a fallback option, right? If this doesn't work. Now, in my case, it's always been academia. So I know that if at some point it becomes impossible for me to practice because all the judges have seen this person as a troublemaker and just don't want to see his face, I can always step out and go into academic work, and that's a viable alternative career option. That's what makes it easy for someone who is economically, who's solely a practicing lawyer, and therefore in that sense their career is in the court. That luxury isn't there. So I think that's again the straightforward answer there.
Okay, may I just ask a short question and then we'll wind it up, if I may. Is that, you needn't name the judge. Have you ever got grief from a bench or from a judge? Have you been stared down and thrown out of court? You've been given a hard time? Surely they all read your blog.
It may have happened, but there was enough plausible deniability in what happened for me to not really be definitive about it. So
in simple English.
So I felt that there were some observations that seemed to refer to what I was doing, but they were indirect, and so I can't really say for sure that they could just have been observations in general.
But you've been quoted in judgments, very...
that's citations. So citations, of course.
No. In fact, in your book, he refers to how the next morning there was a conversation in the court about the court getting maligned.
Yeah.
So...
All right. So I think when Gautam starts obfuscating, it's time to close the program. So such a clear thinker, etc. So thank you so much. Thank you for writing this book, Gautam, and thank you for the publishers for sort of carrying a bold piece of work, unsealed covers, and such a good idea that you didn't have it sealed up for us to have to tear through the staples and unravel it. So that was brilliant. So thanks very much for coming, and thank you very much and a very good evening.
Yeah, and I've been told to say that the books are available for sale outside. So
yes, do buy the wall.
Thank you again for coming on this Thursday evening.
Yeah, sure.